Good evening. Welcome to Devereux Chambers and to PIBA's evening seminar programme. We have this evening from Decker Chambers James Byrne to talk about fatal accident claims. James is a junior who has a wealth of experience in fatal accident cases, having been instructed in the Tunisia terror attacks and the Croydon tram disaster. This is a case, this is the first of our lecture series for several months. It's a lecture that's being run hybrid on Zoom and in person. It's good to see a few familiar faces here in the room in Devereux, and it's good to see that so many of you joined on Zoom. No PIBA announcements, I don't think, other than to remind members of the Oxford Conference, which is taking place in a couple of weeks' time. We hope to see many of you there in person as possible. So without further ado, I'll hand over to James, who's going to talk about fatal accident cases.
Thank you, the camera here. Good evening, everyone. Thank you for coming to hear me give this talk on the building blocks to fatal accident claims. I'm grateful for everyone who's actually turned up in the room. I would say it's standing room only at the moment for those on the webinar. If people want to come in, there's speakers outside, but those lucky people that are in, I'm grateful for attending. And of course, you've got people listening in on the webinar, and I'm grateful to you as well. This is going to be a whistle-stop tour through fatal accident litigation and how to build claims. I'm going to look at it both from the payment angle and from the defendant angle. So let's get started then with the excitement. Well, we can do it. The slides work. Hold on a second. There we go. All right, I'm going to have to ask my beautiful assistant to change the slides. Right, so welcome. I told someone today I was going to do a talk on fatal accidents, and the first thing she said to me, she said, "Oh, I hate fatal accidents. I absolutely hate them. Not only are they miserable because the clients are miserable, but also because I just don't understand them. And then I've got to relearn the law, and then it's a completely different personal injury. It's very difficult. I don't want to do them." And so my response to her was, well, it's actually very, very easy. Once you learn the law of fatal accidents, you've learned it. Not a lot changes. It's as you will always know, and every lecture that I've ever been to about fatal accidents starts with this point. And I'm going to start with it as well, because it is such an important point. Fatal accident claims are a creature of statute. You can't bring a fatal accident claim in common law. And that means that it is a rather predictable claim. You don't have to keep looking up recent case law. It's very slow moving. It is the tortoise of litigation. So once you learn it, that's it. You don't need to refresh your memory again. So when we look at fatal accident, we deal with three pieces of law, really. We've got the Law Reform Miscellaneous Provisions Act 1934, the Fatal Accident Act 1976, and the enemy of any decent Tory, the Human Rights Act of 1998. And as a good Tory as I am, that act has just come in and it's muscled in, and it's ruined everything for us with its reasonableness and giving people rights, so we don't like it. But it's not really that important, saying that as a Tory and as a lawyer, in fatal accident, but it is something that we now need to consider. So when we look at the statute, always having them in your mind, the Human Rights Act and whether we are Human Rights Act compliant. I'm not going to talk too much about the Human Rights Act today because I find it hard to talk about it with my Victoria hat on. So I would suggest there is a chapter in Kemp and Kemp on the Human Rights Act, which is brilliant, and it does a really lovely job of summarising it. Right, so if we can go to the next slide, I'll try again and see if I work. Oh, I do work. The Law Reform Miscellaneous Provisions Act. Now, that slide is a very good summary about how much I'm going to talk about that today. It is essentially any personal injury lawyer can deal with this act in a moment. It's the cause of action that survives to the estate. You're doing your PSLA, you're doing your special damages. important thing, the only things I'll talk about in PSLA are these. There has been a change recently and a recent trend in pleading PSLA that you can now plead for instantaneous death. Now, in the Tunisia case, we did that a lot. It was a case where some unfortunate people were shot on the beach and people were murdered, didn't know that death was coming around the corner. And we claimed, not large amounts, but small amounts for that death. And there's a recent case called Chaucer, which is a good case anyway, if you want to go to sleep and read a little bit about fatal accidents, that supports that you can claim for near instant death. There's a man in a minibus with his family, crashed, it would have been seconds, but he knew he was going to die. Also, the court would also allow awards. The typical PSLA is Chapter 1 of the JC guidelines, but also be mindful of Chapter 6, which is industrial diseases. Special damages are exactly the same as they always are in all PA cases, apart from one thing, obviously, and that is there's no lost years claim, because that is principally dealt with by the Fatal Accident Act, and also your lost years are not there because you're dead. But you may want to think about that. In industrial disease cases, sometimes you're going to have to make a decision whether it is better to bring the claim pre-death or post-death, especially where it's short-term life expectancy, because when you do the maths, it may work out that one is actually more valuable, particularly where there's more dependence involved, than the other claim. So keep that in mind. The only other issue I'll talk about in terms of this act is probate fees. If your claimant plead them, don't worry about it, just plead them. Legally, you're not entitled to them, except in circumstances where it's necessary to bring the claim. Those circumstances occur very, very rarely nowadays. But plead them, defendants often allows them in the watch of everything. They shouldn't be too high. If you're a defendant, always look out for someone pleading them and don't allow them. Okay? So let's get to the really good stuff. The Fatal Accidents Act 1976. A great act, a short act, so brilliant for me. 7 sections to it, and they're all very prescriptive. So what is the best starting point to have a look at? Well, let's look at when you can bring a claim in the Fatal Accident Act. There are some pretty standard tests in terms of to bring a claim. The death must have been caused by the Tortious Act or Tortious Act. Interestingly, I just thought I'd bring this claim up because suicide was challenged in 2007 in Core and IBC. Defendants arguing that suicide didn't fall into the Fatal Accident Act. Now, obviously, it's in common law, it would do. You can see it's causative. But they argued quite cleverly that it wasn't reasonable. Now, this is a case where a man was hit whilst working in a factory, working in a car line, by a big piece of sheet metal. It caused him some very, very serious head injuries. He survived them, but then went on to suffer quite significant depression and a few years later took his own life. And the argument was, it wasn't, well, it caused the death. It was, well, it's not reasonable to expect a defendant to have to pay for damages in these circumstances because the act is prescriptive. And that argument was roundly rejected on the basis that, look, it really is, it's not a reasonable argument, it's a causation argument. We all know that depression can lead to death, and that must have been foreseeable to any defendant. If it's foreseeable that you suffer depression, it is foreseeable, though uncommon, that you may try and kill yourself. Worth looking, of course, and always remember in fatal accident cases, Accident Act, FAA acts, there is contributory negligence, and you can plead contributory negligence, and deductions can be allowed for that. So who can bring a claim? Well, I'm not going to go into too much detail in respect of that. It is, again, favourite word of the night, prescriptive. You can't go outside those 3 persons, and persons whose benefit is number 3 are dependents, and we're going to go and talk about them in a moment. The important thing to do, to think about though, when you bring a claim and when you're defending a claim, is that you're only allowed to bring one action. So you can't have steps in where dependents, maybe the family's fallen out, bring their own separate actions at different times. It's all got to be brought under one umbrella. If you miss the boat, then you miss the boat, and it's an abusive process, and the case will be thrown out against you. We also must remember when we're thinking about who are dependents in this litigation, or who we're bringing it for. Whilst we want to, as a claimant lawyer, you want to make sure you get everyone in that one action. Remember, it's one pot, it's a finite resource, it's one cake. The more dependents you have on time and resource, the thinner the slices of cake that go to people that probably matter, children and partners and so forth. So be careful about that. But if you're a claimant lawyer, you have to make sure that you've got all your dependents in, or at least you've asked the question, because you don't want to be held responsible if more dependents come along later down the line. For defendant lawyers, when you're thinking about a claim and looking at it, a good case to remember is Poor and Brothel Bank, which is a 2019 case. Very, very diligent, sensible defendant lawyers wanted to settle the claim early. The father of this poor young man who was killed served a pre-action letter. An offer was made to settle the claim for the whole of the claim with the father before issue, and he accepted that offer. A couple of months later, the mother and the daughter then sent a pre-action letter, and the defendants turned around and said, well, no, we've settled the whole of the claim. And the court said, no, sadly you haven't, because this rule only applies once the claim is issued. So if you're defending a claim, you've got to make sure that the claim is issued before settling to avoid the risk of further people coming up in the woodwork later. So a bit harsh on the defendant lawyers in that case, but there we are, that is the law. So who do we bring the claim for? Well, short answer is dependents. Again, a prescriptive list, which is great. You can't be a dependent if you're not in that list. And the list is quite wide ranging. I have actually dealt with everyone in it. Haven't changed much since 1976, apart from to bring in 2-year cohabitants, which is nice, and civil partners, which is, I think that was 2002. So it glacially keeps up with society changes, or societal changes. And it does come up, it does throw up some rather strange scenarios, but the rules are the rules. To give you an example, if you are going out to a war and you get married in Gretna Green, get shot the first day, then you've been married for 2 hours, you can bring a claim. If you have been with your partner for 30 years, but for reasons you don't want to live with him or her because of some irritating habit they have, you can't bring a claim. And so a lot of the time, is that fair? We've got to then start thinking about what would happen if that nasty Human Rights Act got involved. It may be that this is open for wider scope, but people just don't test those arguments, or haven't really tested those arguments very much in the past. But if you're not on the list, you're not getting in, effectively is the rule at the moment. And now there are some rules that you need to take into consideration when thinking about who are dependents. Stepchildren are considered as full children. They're not, the Harry Potter sort of under the stairs, not wanted type of things. Adopted children are treated as legitimate children, and children in civil partnerships are the same status as children in marriage, which, I mean, is all sensible, good stuff. Note, though, here we go, a child of surviving unmarried partner is not a dependent, even if living in the family unit. Now, this is a case that a friend from 39 Essex Street did recently. She told me about it. Claimant is the wife. Oh, sorry. Claimant is the cohabitee with her deceased partner. She changed her name and her child's name from her first marriage by deed poll to the deceased name. She didn't tell the child that he was adopted. And he lived happily until the age of 16, thinking that his father was his real father. So, for all intents and purposes, the child is the son of the deceased, but he wasn't allowed to bring a claim. It was ruled out. Now, in that case, she did the very, very sensible thing, and she told the defendant that if you want to argue this point, then we'll take it to court, and I'm going to run a human rights argument. And the defendant caved in. They didn't want to have that argument because it did seem that it wasn't. It didn't seem compatible with what is right and what is fair, and they didn't want to risk a judgment in that case. But again, it does show how prescriptive it can be, and if you've got a defendant who wants to be resistant to those types of arguments and take a very legalistic approach, as is completely the entitlement to do that, well, they can do. You've got to be aware of it. There's obviously the case of Swift, which I'm sure we all know, was a case where it was brought to court on the argument that, look, why is it fair to discriminate against cohabitees living for less than 2 years? So why can't I live for 1 year, 9 months with my partner? What is the difference between me and someone living with their partner for 2 years? That argument was rejected in court on the basis that, look, Parliament has a wide discretion over social and economic policy, and there was legitimate reasons to restrict the list of dependents. So you've got two examples there, one where someone living 1 year, 9 months was refused dependency, and one example where a child lived with his father for 16 years. The defendants decided not to run that as an argument, fearing fearing Article 8 of the Human Rights Act. So anyway, let's go and have a look at what we can claim for. Nice, easy ones. Bereavement award, we all know what that is. It's in England, it's £15,120 to compensate you for the pain and suffering of loss of a loved one. Now, that derisory figure is probably about right for my wife's love for me, but for most families, it is a paltry sum. We do better than Northern Ireland by that, not by much, but we're a little bit more compassionate. Scotland, on the other hand, is ruthlessly compassionate, and it is dealt with very much like a PSLA claim, where you can have quite high awards. They tend to be in the tens of thousands, but there have been awards where you particularly love your wife, where you had £100,000, whatever course that out was. I don't know, but there we are. So Scotland is, as the S&P would say, better than England, and there is the evidence for it, a more compassionate country. And now there has been quite a long campaign by people like Paul Beaver to try and amend this so that we have unity with Scotland. And we have unlimited awards, but the government, in their infinite wisdom, has said, no, that's a terrible idea. We're not going to be compassionate at all. Sort of a Bradman approach to justice, I think. So here we are. Well, who is eligible for a bereavement award? We're going to concentrate on England and Wales here, mainly because that is where we're located. Again, it is a prescriptive list, very narrowly defined, more narrowly defined than dependents. So just remember that. And again, we've got the list there of who it is, and I'm not going to read that out to you. Again, civil partners were introduced into that list. It's important to remember married means exactly what it says on the tin, married. You can be in the last days of your divorce, just about to sign your papers, and for some unfortunate reasons your partner is poisoned or clubbed to death anonymously just outside the door of court by a masked husband or wife, and you can bring that claim. There's a quite interesting case, it's Hayes and the South East Coast Ambulance Service from 2015, and that was a couple that for their sins got married, then divorced, and then got back together again and were engaged and were just about to be married, and the poor husband or the poor fiance popped his clogs in the most unfortunate way, and the court said, nah, you're not married, so you can't come in. Remember this when you're dealing with children. Parents only suffer an award worthy of bereavement if a child is under 18. If they're over 18, they can go sling a hook. And it's from the date of death, not from the date of injury. So there have been cases where children have, in particular in car accidents, where children have been put in comas. And they have, the period in coma has gone through the period of their 18th birthday, and you lose your £15,120 from that. Parents of legitimate unmarried children under 18, we saw the rules previously. It's quite a weird one, that. So it's the mother of an illegitimate unmarried child, meaning that the bloodline works there, so you can claim bereavement award there. But the father, who is illegitimate himself in some ways, is not entitled to claim. The interesting question is, well, does adoption fall into that? Well, the father, I think it does now. It hasn't been tested in court, but if you've adopted the child, as we've seen from the list of dependents, it would seem that has to be parity. If not, the Relative Human Rights Act will come and get you again. But there are some quite interesting cases that you're going to start seeing coming through about surrogacy, because that's become a lot more common in this country, which is a good thing. But how do we deal with that? Particularly where you've got surrogacy, where the father and mother, or the death of the child is quite early, and there hasn't been time for adoption. So there hasn't been a lot on that yet, but it will filter through into the law. But my suspicion is that if anybody was stupid enough to run an argument that they shouldn't include in the list, Human Rights Act is going to come in again and say that that's not compatible. Cohabiting rule. Again, I think we all hopefully know Smith and Lancashire, Jackie Smith's case, where it said it's not fair that why isn't cohabiting 2-year rule applies for dependency? Why doesn't it apply here? And the court said, yeah, it should do. It's incompatible. And eventually, even though that case, I think it's 2017, that came to force in 2020. The government dragging its heels a little bit on that. But as made this point, again, there's no uniformity between England and Scotland. I call England and Wales and Scotland. Again, Scotland's far more generous. So if you are doing some Scottish cases, just remember that you need to make sure that you're looking at what the list is in Scotland. Again, there's no plans to reform this. That list is quite happily stuck as it is. And in fact, only last year, the government said they were going to keep it that way. And the potential Labour government have also indicated that they've got no plans at the moment to change. Now, what is interesting on that list is obviously that children can't claim bereavement award. So when you're doing these sorts of claims and you're a claimant, remember that you've got Reagan and Williamson, which is a case which gives you an award. Parents can claim it also on top of bereavement, but it's an award for the loss of maternal care. It is what is it? It was termed out the specialty quality of maternal care. Those awards tend to be lower than bereavement awards. They're usually in the low thousands, £4,000-5,000, but they're worth pleading. Now, we're going to have a look at, is there a dependency? Well, when we look at dependency, we've got to remember there's 3 broad categories: financial service and what I call gift fringe benefits. Dependency with gift fringe benefits are things like paying for university, Christmas presents, things like that. Fairly simple. Service and financial dependency we're going to go into in a little bit more detail. But remember, as I've just made a point earlier, you are dealing with a finite pot in all these claims. You're always going to have to justify them in the sense of, were they earning that much money? Did they have that much time or dependence? Less of the pot to go around. Right. Okay, so how do you become a dependent and how do you get to claim? Well, prescriptive list, but what makes a dependent actually be allowed to claim? Well, it's the reasonable expectation of pecuniary benefit. And that needs not to have been realised at the time of death, which means that effectively, as long as you can show that there was an expectation that you were going to get a pecuniary benefit, sometimes often the case is, well, they were going to pay for my university fees, they were going to buy me my first house. Those are all pecuniary benefits, but they're all obviously in the future. So you don't have to realise it at the time of death. Now, the level of proof, it's not on the balance of probabilities, it's lower than that. It's a substantial possibility, which is useful when you're doing that. So when you're looking at societal possibility, it's a chancer for creativity, if I can put it that way quite mildly. This type of evidence is usually very difficult for defendants to object to and actually to resist, because it's usually quite anecdotal. You've got mum, daughter going, yeah, he was going to buy me my first house and a Ferrari. Oh, he promised me that. And when I was 28, he was going to buy me tickets to Disneyland or something like that. And as a defendant, it's very hard to go, no, he wasn't. Yes, he was. No, he wasn't. Yes, he was. Right. Okay, fine. Well, that's the best I can do. A lot of the time, when you're building these sorts of cases as a claimant, it's always useful to have the background documents that support the financial situation. But you don't need it, because remember, a lot of this is effectively like futures. It's sort of crystal ball gazing. Courts do tend to be fairly sympathetic to little Jane, who's just lost her father, as against the big bad insurance company on the other side. So remember that on both sides. It's slightly unfair for defendants in that respect, but that's the nature of the system. Now, are there limits to a dependency claim? Well, you must arise from the family relationship. That is really important. Obviously, you can see that I crammed in different sized text in this one, so I do apologise for that. A series of different fonts and underlinings, which probably gives an indication of how my presentation skills usually are. Now, as I say, good examples of a family relationship. Very famous case, Burgess and Florence Nightingale Hospital. Professional dancing husband lost his partner, and lost earnings because of it, and he made a claim for those lost of earnings. The court said, no, that's not a family relationship, that's a business relationship, so you can't claim that. But then there are some cases like Cookson and Knowles, where Cookson, she couldn't carry on a cleaning job because her husband would turn up every night and help carry the heavy hoover, and he did that under assistance. And the court said, well, that's not a business relationship, that's love. So that was nice. And Helen Witham was another one, which is foster caring, which was a business relationship, but the court found that it was actually integral to the family relationship as well. So decent people getting decent judgments, I would say. And obviously the third thing is it's got to occur but for the death, but I don't need to go into that because that's just common sense, or at least I would hope it is. So let's have a look at probably the most famous part of the FAA, and the one that most people tend to know, and then that's section 4, and that is when you're assessing what the damages are, you must disregard benefits accrued as a result of death. Now, again, be creative. Benefits have are widely defined, and like you can think of things like insurance. The big one is usually widows' pensions. I've got a case at the moment where a man who was an ex-military, ex-police force was killed in a chemical negligence accident. His wife now has quite a substantial widow's pension because of his accrued pension from his previous careers. We're not counting that, and it's changed the difference in this claim by hundreds of thousands of pounds, which is nice for her. The defendant is a little bit irked by that, but that is the law. Now, there are some arguments that have been started to be run by defendants to try and oppose this. Let me just say, look, the argument that, well, the defendant's better off doesn't work, and that is up and white. But there is Wood and Bentex has been used very recently. Now, that case involved investments and business and what happened to the capital post-death, but they try and now relate that to where it wasn't, where that wasn't considered not a benefit, and that case is now tried to be extrapolated to things like pensions and other investments, and possibly my favourite judgment ever, because it said the dependent cannot, however, inherit the goose, but claim he's been deprived of the eggs, which I think is denning in its beautifulness. Good case, but the courts recently have said, the case of Robertson has recently said, those arguments don't apply. You've got to look at what the Act says, and if there's benefits accrued from death, well then I'm afraid that if you're a defendant, you don't count it. If you're a claimant, happy days, you do count it. One of the few happy days you will have, no doubt. So anyway, other things that we need to just want to check. I'm not going to miss anything here. So when we're talking about defendants being better placed financially, what we do look at is also things like remarriage. And an argument that was run, there's a case called Stanley and Siddiqui, where father, mother, child, mother died, and he remarried, and apparently the new wife was a much better mother and took a lot greater care of this poor child. And the defendant said, well, actually, we need to include the care that this child now having in the service dependency claim. And the court said no, because that's a benefit that has been accrued from this death. Which seems quite a stark decision there, but there you go. And so they also got the claim for the loss of the mother's dependency. So are there limits to dependency claim? Well, look, things that you should not take into account is marriage, like if they're going to, what are the prospects of remarriage? Because obviously, as we've just done the Stanley and Siddiqui case, that can influence the level of care that people get later, or the level of loss. But the court says no, you don't take that into account. The court is allowed to take into account, though, when assessing the value of these claims, that the marriage that you were in was likely to break down. Now, best case in respect to this is a case called Dazel and Donald. And Mr. Dazel was one of life's real good guys. He left behind his wife and his brand new little baby, and killed following a motorcycle accident where his pillion passenger was seriously injured, filtering through traffic. He had been recently demoted by the army, so good start. Had failed to pay his mortgage and all the bills for the household, had left his wife high and dry, but really put a cherry on the cake was that the pillion passenger that had been badly injured was his mistress. And his wife only found out about said mistress after the accident and his death. Now, the defendant said, look, at the time of death, the marriage was likely to break down. And the court agreed. They said, look, for her sins, Mrs. Dazel loved him. But if she had found out that the pillion passenger was who she was, the marriage would have lasted. And it made a broad-based deduction on the overall award. So what a lovely little gift Mr. Dazel gave them when he departed this mortal coil. Again, very small writing. I'm sorry about this, but this is fairly straightforward stuff. So that's why I crammed it all in. How do you do financial dependency? Well, the rules really are from Harrison Empress Motors. And you do it as a rule of thumb. Look, if you are, I'm going to show you the formulas in the next slide, so don't worry too much about that. But if you were married and you have a partner and child, well then, or children, it should be, well then it's a 75% deduction or 25% deduction. And if you are just a dependent, then it's 66.7%. Now, the percentages that are used when you calculate financial dependencies are a rule of thumb, and there's Harrison Owen Martin, which set that out. But they're not train tracks, they are guidelines. And there are a number of scenarios where you can fiddle with that rate and try and change it. Now, often it's in the party's interest to do that. If you can bump up the percentage, then that for claimant, that's great. If you knock it down as a claimant, as a defendant, that's great. So, you know, we've got two cases there of Cox and Payton, which are two good examples of that. One being high income, which got the rate up higher, and one being low income, which got the rate lower because it's joint housing expenses. What if both parents die and you bring such a claim of financial dependency? Well, that all goes out the window. You're meant to do it in a more forensic approach. In Diwali, it was 50%, and that literally is getting a forensic accountant to look at the finances and say, well, this is what they were spending, this is what they would likely spend, and then just doing this and coming up with a figure that you actually like and paying that, because it's going to be argued either way or not. So look, here are the basic calculations for how you calculate financial dependency, they don't change. And I'm not going to go through them because you can all see what they are. And I dare say that any fatal accident book is going to set them out exactly in that way with an example. When we look at earning capacity, when we've got to look at what the not just what the deceased is going to earn, but what the dependent themselves, usually the partner, was going to earn as well, usually the wife or the husband. Now, here are some rules that you should all know and take into account. If the dependent worked pre and post death, then you include what their earnings were going to be, and it was their intention, you include those. If it was the intention of the dependent to give up work, but now they must work following death, you should argue that that's now benefit accrued from death. It shouldn't be included. And there's a good case of that's Williams and Welch Ambulance Service, which argues that. Now, what if the dependent intended to give up work to have children? Well, you don't include that, or the argument at the moment is the case law is you don't include that unless they were pregnant at the time. And the reason being, because you have to look at the dependency at the time of death, and an aspiration to get pregnant is not enough. It's got to be, you've got to be pregnant. Whether that will stand up to legal test now, I'm not so sure, because it does seem a little bit inconsistent with the other authorities. But there we are. Especially now, it doesn't stand up to the fact that, as we go back, remember the dependency test is about substantial chance, substantial possibility. It just seems that Higgs and Drinkwater case that hasn't actually come up again could be challenged. I suspect it's mainly because people realise that it's a very good argument in this day and age, and they come to compromise in respect to that. Now, of course, we've got if the dependent was working prior to death but then stops due to death, the court should take into account their earning capacity, because that is a relevant factor. And if the dependent is not working prior to death, never intended to work, but now needs to financially support themselves and others, or then you don't take it into account, because again, it's the benefit accrued from death. Okay, pensions. A point that Stephen asked me to remind everyone of is that it's the same formula as loss of as dependency. But remember, claim state pension, because it is quite valuable. It's 12 grand a year, or 12 and a bit a year. Now, there are sometimes arguments about categorisation of the pension, if that's a benefit or not. But again, don't worry too much about that. People don't like looking at pensions too much. So if you plead it or defend it, you can have that quite that decent multiple account there. And as we discussed earlier, widows' pensions are a benefit and shouldn't be included in the calculation. Okay, so there we are. That's a little bit more about state pensions. State benefits. Now, obviously, state benefits not being Section 4 benefits. A lot of this case law on state benefits is becoming outdated because of the way that the benefit system is now structured with universal credit, and it's quite hard to unpick certain parts of it. But look, the basic rules still apply. If you're receiving a certain type of benefit before your partner's death, and then they die, you lose that benefit, but you get another benefit which is very, very similar. The court of tenders say there's no loss, so you can't claim the loss of financial dependency on that, on the loss of their benefits. But if there are very individual benefits, such as in Cox, the wife was quite disabled. Husband was disabled as well, but he was a carer for her and he got a carer's benefit. The loss of her disability benefit was considered a loss which could be claimed. Strangely, his carer's benefit was not. But that was because it was considered there wasn't a loss because he got something else instead. But so you do have to look at benefits, do look at it carefully, but again, they can be quite considerable. So an example, and this is an example Stephen wanted, I think he had a case and he wanted help with it.
Yeah,
so,
I had a couple of cases that I settled and I want reassurance that I was right.
So when I got those 6 panicked emails at 2 in the morning going, are you sure that's the law? And I said, yes, because I'm against it in the same case next week again. So you've got a son who lives rent-free with his mother in a housing association house, and the layabout doesn't contribute to any bills. What claims are there? Well, the Harrisville Fund doesn't work because it's another son. But can you claim things like lost rent? Well, of course you can. He's now got to go out and find new rent. He's got to go and pay for a house. So how would you value it? Well, the way that I would value it would personally be I'd go and look for similar type properties that he's now lost and seek the whole rent for that. The defendant would probably turn around and say, well, no, don't do that. You've got to actually have a property which is more reasonable with a deduction because the mother's now not living there. He can claim the cost of bills, but a defendant again could be entitled to say, well, hang on a sec, you've got a duty to mitigate your loss. Have a look at what state benefits you can get. So those type of cases are happening quite a lot now. Sorry, and I said both Steve and I have had them. So that's financial dependency. I'm just mindful of the time. We haven't got too much more to do, but I just want to do loss of services. Now, remember, loss of services claim are different from personal injury claims, but it can cause confusion because people very much associate them with care and assistance. They're not. They are different and treat them differently. Again, the starting point is statute. It's Section 3 of the Act. And always look, you can be creative in what is a loss of service. I mean, I'll give you some of the standard ones there. Pet care, IT skills, bookkeeping, massages. I know that, disgusting to say that, but there we are. Not an insight to my marriage in any way whatsoever, I promise. But yeah, you can have massages, you can have all sorts of things. So if you're claiming, think creatively about what have you lost. Running the household is obviously very important ones as well. There's a case called Bentley which shows you how creative you can be, and that was brought by a daughter for the death of her mother, where she brought a claim saying that she had lost childcare, and obviously that's not her mother was going to give up work to look after their granddaughter, and the reason why that was so creative was because the daughter hadn't been born yet, and so if you think about that, she was pregnant. So if you think about the time of death, then going back to that case of Higgs where a claim wasn't allowed, where there was an aspiration of a child. You can claim service dependency where you're pregnant and you lose a grandparent who's going to care for your daughter in the early stages of pregnancy. When you look at these claims, you've always got to remember that you're dealing with this on life expectancy. It does apply also for financial dependency. You're going to have evidence of what is the dependent's life expectancy, what was the deceased life expectancy. So that make sure that they dovetail, because you can't claim if they've been dead anyway, which is quite obvious, really, isn't it? So how does the court approach service claims? Delicious words, a large element of judicial discretion. So in some courts, brilliant. In some courts, dreadful. So in London, you're going to get rubbish. If you go to Bristol, you're going to get everything you want. So be mindful of judicial discretion, because what judges do is that they will make lump sum, fairly broad brush reductions, or through the contingency, because you do use the standard multiplier approach. Judges do worrying like to stand back and consider what is reasonable compensation, and obviously that's reasonable in their eyes. And look, the test is there. It's what would the deceased have provided as against the anticipated costs of meeting the dependent's needs. Now, quite wordy there, but you've got to remember this, that you are dealing with what are the needs. It's not the system that's already in place. So you do have scenarios where, especially with children, where the father or mother on their own is struggling along and they're doing their very, very best. In fact, I've got a case today where the mother is doing her very best. She's really struggling and she's not working because she's trying to take care of children. Now, the defendant can't argue in law, well, that is the system that's in place, so that is the system that is going to carry on in the future. The argument is, well, what do the children actually need? And in that case, they need a full-time nanny because the mother needs to go back to work for her own sanity, and the children need stability or someone going to be there all the time. I want to say full-time nanny, it's because one of the children is very young. Obviously, as they go through school, the needs of the nanny and the needs for care will reduce, but you need to think about things like that when you're looking at service dependency claims. And look, as I say, look, loss of care, it tends to be the largest of all these claims, and you can get some very, very large figures. Don't just think that these claims start at 18. Man children like me were being cared for by their parents until I was about 26. In fact, I still got an allowance until I was 28, and that stopped on my wedding day, which is my great disappointment. So be mindful of the fact that the family dynamic has changed very much from the olden days, where at 18 and out you go. It's kids live at home a lot longer with their parents, and so don't just want to cut that off at 18, particularly where people are providing homes for their children, and so that they can save money to buy a home in later life. As I said, look, we've dealt with this already. Look, you are meeting the needs of the child. It's a factual question. As I said, look, if it's already in place, doesn't mean that that's what they actually need. You need to look at that. Care does change over time, and if you're claiming, you're entitled to claim an enhanced commercial rate for care. You don't claim the gratuitous 25% discount. You claim it as professional, and you go from there. And you can claim and the reason why it's enhanced is because the nanny is going to give that child the love and care that the mother didn't, and you're going to be able to plead that in £2 extra an hour. So do plead if you're claiming, do plead the commercial rate with enhanced, and defendant look out for that, because that seems like it's fairly settled, fairly reasonable to do that. As I say, that anticipated costs are not just future anticipated costs. You need to look at the costs of the date of death. Okay, so those needs costs go from the date of death until the future. And as I said, we've been dealing with it in more detail. The Noah and MOJ, the fact that the widower decided to manage himself after death is why not disentitle him to sue for and recover damages for the cumulative loss he has sustained. So all good and simple stuff there. Again, what if you don't need professional care? Well, court will still award commercial rate, and the court will normally make a deduction though on the commercial rate to reflect a net value. So commercial rate net, not gross. And like the Housecroft is that standard 25% deduction. I know that some people argue 33%. If you're a defendant, I know you can do that, and usually that's roundly rejected. But give it a go, see how you get on. You might get a rather flopsy claim on the other side who gives in on that point. And where there's foster case in Hill, the fact that the father stayed at home, that's not a reason to make reductions. It was a foster case, he was acting as a foster parent, and so well, it's still a commercial rate. So there we go. Now, is that working again? Or am I... Oh, there we go. What happens if a family member gives up work? Well, courts can consider making awards for family members that give up work to care for dependents, but it can work both ways. Again, you've got to look at what the reasonable needs are. 2 examples, Bell and Highgate, the court held it was not reasonable for a father to give up his higher paying job to stay at home and look after his children after their mother was killed. They said he had to go carry on being a banker and he could get a nanny. I mean, 2005 case, you would have thought there might have been a little bit more compassion. It's not 1872, but no, that's what the court said, and that was all because of reasonableness. But that could have gone either way. And then we've got Bailey and Barking. Again, a court found it was not reasonable for father to give up his lower paying job to become full-time carer. So the father's shot either way, really, isn't it? Just got to have the exact amount. But in that case, the lower amount was awarded for care rather than loss of earnings. But again, look, those are just 2 cases that I pulled out. You can find examples of where the court will go the other way, and it could have easily gone the other way on both decisions. Again, it's this famous word, judicial discretion. So there we are. Reducing the value of the claim. Well, look, if you're a defendant, you've always got to make sure that there's no double recovery where you've got children at school or being sent to private or public schools. Claim that we've done, pleaded recently that the need is a very serious brain injury case, and we're pleading that the daughter and son need to go to the local private school because it provides a round-the-clock care. And it gives them breakfast and gives them the evening, and it keeps them away from the father who's got this very serious brain injury and the mother who's now deceased. And we're arguing that, and we're arguing nanny costs on top, and the defendant's saying, well, you can have one or the other, can't have both. Make sure that the claim is not bigger than the sum of its parts if you're a defendant. Make sure that when you're looking at things, you stand back and say, well, hang on a sec, this mother's a superwoman. She's providing 48 hours of care a day. And so be careful and make sure you're totaling up and looking at that to make sure it does work. Getting down and dirty, look at the state of the relationship if you can. See who the pillion passenger was on the back. What about the children were likely to be adopted? Well, both parents died and the child was later adopted, meaning that she's now the legal child of the adopters. The claim for the deceased mother's services stopped in that instant because they've now got a legal mother, which is quite harsh, really. The father's financial services were reduced, taking into account the father's financial contribution. Now, it's slightly there in the warning, isn't it, involved that, if that case had been appealed, what would have happened? I imagine that the court would have thrown it out because the Section 4 benefit, being adopted was a benefit free from death. But they didn't appeal it. They just left it as it was, which I personally wouldn't have done myself, but there we are. What about the illegality or as the source of the dependency? Well, if you're a child and your father is a career criminal, you can't claim, even though you have no knowledge of his criminal enterprises. In that case of Bernard and Edmund, it was the wife. It applies in principle to all of them. She knew that or likely knew in that case, it wasn't she knew, she likely knew that her husband was hooky and was getting money fine nefarious means. And the court said, well, look, equity applies. Remember that from law school, actually does have a use in the courts. Equity applies, she can't claim, you can't claim dirty hands. So that case was thrown out. It won't work, though, that sort of argument for minor infringements like tax evasion, tax avoidance in some ways, or if you do minor criminal acts, because it's just, again, Human Rights Act, it just wouldn't be fortunate, and also I think that it even fall foul of equity law in any way. Final point, very low down, because I mainly do claimant work, I don't want defendants to notice this point too much. If you're a defendant, always look at contingencies, because that is always going to be scope for movement on that, the risk of what is going to happen in the future. Don't just accept the PI calculator figure that you're given. Do your work on your contingencies, because there is serious savings to be made by looking at those. And I think that, with a lot of advertising for my chambers there, is it. So thank you very much.
Thanks, James. I can see that we've got two comments to the questions and answers. The first one was a fairly major one. Can the presentation document be shared? I think it will be uploaded to the People website in due course. The second one, there's a question there, which can you read that, James? Disregarding the widow's pension as a benefit, is this only in respect of a pension that's provided to the widow as a result of the death, as opposed to the widow's state pension, which she'd be receiving in any event? Presumably you do include her state pension in the dependency calculation, so I think that's a simple one to answer, isn't it? Yes, you do, because as the questioner said, that doesn't flow from the death, so it's just part of the ordinary income of the household.
Yeah, you need to be, with that one though, you need to be careful, because sometimes your categorisation pension can change because of the death. So you want to be claiming the death that was at the time, the pension at the time of death accounts, but if the pension amount goes up because the partner dies, well, then you don't include that difference. So just be mindful of that.
One or two questions in the room, I think.
The case with the, I think it was the wife that was is she the criminal on that one?
No, it's not.
Sorry, the husband. Before that case came up, I was actually going to ask a question about that, which is, in terms of the divorce case where there was a potential divorce and that was argued by the defendant, there was a reasonable prospect that they would have divorced. Could you argue that as a defendant where let's say you have a financier who dies and it's known to the parties that he was under investigation at his bank at the time, and there was no knowledge by the partner as to whether he was or wasn't committing fraud. But could you look at that in terms of, if there was a high likelihood that he would have lost his job at Goldman Sachs and ended up having to have another job, are there cases that look at that in terms of financial dependency?
Well, in that specific example, going back to my fraud days, when I used to prosecute fraud, his earnings are legal because he's getting paid. He may be doing something illegal in his work, but it's incidental to the fact that he's doing a job where he's getting paid. But say you're self-employed and you're clocking cars, for instance, and you're a dodgy second-hand car salesman. Well, then it is an argument, but your problem is it's got to be done at the time of death. So if I'm an argument, you've got to look at things as they were at the time of death. And at the time of death, he didn't have a criminal conviction, and he never has had a criminal
That's
conviction.
why I think that it was interesting about the divorce, because I think that's an inconsistency. Just because he was known to have the mistress on his motorcycle at the time.
Yeah,
they
no,
weren't
but
at the time.
there is a difference. He was definitely having an affair at the time. There's no doubt about that. So that was the marriage in the perilous state. In your example, he's being invested for a criminal offence, but as we all know, innocent until proven guilty. So that's where I think there is a difference in that. But if you're a defendant, argue it, for God's sake, why wouldn't you? I mean, the only thing to do, if you get knocked out, then you get knocked out. But I would certainly argue it. But it's going to be a very specific set of facts for that, and it would be difficult. But yeah, I mean, I always say just argue everything and see how you get on, and they can only say no.
What do you do if you're for a claimant and the deceased brought some money into the household pot, but it was quite a low sum compared to the surviving partner? Because that's a situation where the Harris formula doesn't really
Well, then
work.
that's where you argue to change the contributions. So that's where it's where there's a low income. You would say, well, if you're a defendant, you want to try and get that figure as low as possible, the contribution that would make, because the dependency is less. If you're a claimant, you try and want to bump that up. I imagine what I would do if I was in that situation as the claimant, I'd probably go for the Harris rule and say, well, that's a rule of thumb, let's argue that. On the defendant, I'm going around saying, well, no, we need to rebut that because the income, it was so low.
Yeah. But sometimes the Harris rule actually produces a negative figure.
Yeah.
If it's really low.
So then that's where you go. That's where you change it. Effectively.
Just put
change it to your benefit.
Yeah.
Again, as I say, if you don't plead it, you plead it and let someone argue you down.
Yeah.
But you always change it to your benefit.
Yeah. So if you're for the claimant, we just put the full amount in and then let the defendant.
I was fact specific. I would definitely start saying, oh, he's a very greedy, horrible person, spend it on cigarettes, vapes, and bookies. And so, no one. He was a dazer, if you would, type of man. But like, it's fact specific. But you need to plead it in a way that the facts allow you to plead it. You can't put in a case that's inconsistent with what you're told. But you in those types of scenarios, if you're getting a negative, then you amend Harris, because you would say to the court that you've got to take a common sense approach to this. Clearly there was a contribution, and clearly that's been lost, and it can't be.
Yeah. Thank you.
Okay, well, let's wind up that. Thanks very much, James. I think it's very important for me to say at the outset, in light of James' talk, that PIBA is not politically aligned at all. But it is very, very interested to know what official Conservative Party policy is in respect to the ECHR, the former Attorney General, and the question of surrogacy.
It's like blind panic.
So we've all been massively enlightened by that. Fatal accidents, it's been a real whistle-stop tour. I think one big takeaway from me, just hearing someone else talk through some of the issues that I come across very, very frequently, is how tactically astute and aware you've got to be when you're pleading these claims, when you're resisting them, and when you're thinking about how to present them. So thanks again, James. I think we'll stop the recording now. If there are any more informal questions for those in the room, we can ask those to James over a drink. And thank you all very much. Thanks again.